Welcome everybody. This is a public lecture entitled New Developments in Securities Law and Litigation. And without further ado, let me introduce our guest speaker, Les Silverman of Cleary Gottlieb, with 35 or 40 years of experience at Cleary. He's perhaps
More than 40. I'm that guy's age.
He's perhaps one of the best experts on securities law in the United States.
No, I'd say worldwide, but anyway, that's also in the United States for now.
Plus, he and Professor Eakley of Rutgers Law School will have a lovely discussion about Johnson & Johnson and arbitration proposals at the end of the lecture.
There's going to be enough time for that.
Well, that's
hopefully we'll have enough time for that. So
I can do a short monologue.
The floor is yours.
Okay, great. So, I guess my notes say I should say good evening, so I'll say good evening. So, I'm going to focus on the three most interesting cases, I'd say right now, in securities law, in the litigation context, in the case law context. SEC versus Lorenzo, which was relatively recently decided by a 6-2 majority Supreme Court, with Kavanaugh recusing, as Kavanaugh had been on the D.C. Circuit, and indeed dissented from the decision by the D.C. Circuit, and so his colleagues disagreed with him ultimately when it got to the Supreme Court. But that's a very interesting case, recently decided by the Supreme Court. Then the next case I'll deal with is Emulex, and I'll just call it Emulex because it's a private action. Emulex was the defendant below, and the plaintiff has a name that begins with a V, and it's a long name, and you're welcome to see it at the back in the slide. But it's going to be hard to pronounce it, and so I'm just going to say Emulex. That case was a Ninth Circuit decision, and certiorari was sought because the Ninth Circuit disagreed with 5 or 6 of the circuits on whether, in the context of a private right of action under 14E, which is part of the Securities Exchange Act, introduced by the Williams Act, and regulates tender offers. In that context, if you make what's alleged to be a false statement, if someone who's making a tender offer makes a false statement, or a company who's the target of a tender offer, and in response to the tender offer makes a false statement in response, there is a private right of action by shareholders, not by competing bidders. It's Chris Kraft Piper that said competing bidders don't have standing, but the shareholders of the target company do have standing to bring a private right of action if indeed there is a private right of action, which the Supreme Court, before the Supreme Court, there are 2 issues. I'll get into this in more detail, but there are 2 basic issues. One, the Ninth Circuit held that negligence was sufficient for a private right of action. Every other circuit had said scienter is required. And so that was appealed by the company, by Emulex. And then in the course of the papers on appeal, and I'll get into a little bit of procedural nicety with respect to the appeal, but the company, the appellant, said, well, 2 things. Supreme Court, first, I don't know what they said first, but first, scienter has got to be the way it is. There's no basis to go with negligence. And second, oh no, by the way, there really ought not to be a private right of action at all. So it's about time the Supreme Court, which has never looked at 14E to decide whether it permits a private right of action, the Supreme Court ought to now decide it does not. The heck with the negligence, the heck with the scienter, it just ain't no right to bring it. Private. SEC, of course, but not private. So that's Emulex. The argument for Emulex, it's what happens when you post-date a document. Never do it. I post-dated my slide deck, the date of today. I wrote it last week, and when I wrote it, the argument had not occurred in Emulex, and lo and behold, and I was a little sloppy and didn't check the calendar, which I could have, and I didn't. So I wrote that it had not yet occurred, and of course, as of April 17, that is not correct. It occurred on tax day. It occurred on April 15, Monday of this week. I've been through it. I'll give you some quick thoughts about it. I wouldn't gamble on my thoughts, but I'm reasonably confident I know which way the court's going to go, but we'll see. And then finally, of this trilogy of cases is Stoyas versus Toshiba, which is another Ninth Circuit case. Lorenzo came up from the D.C. Circuit. I mentioned Kavanaugh's involvement Both Emulex and Toshiba come up from the Ninth Circuit. Now, Toshiba involves what are called unsponsored American depository receipts. I'm not sure time permits, as we like to say, by going into the subtleties and differences between sponsored and unsponsored ADRs. I don't know. Julia, is that something that the class would know about?
Very briefly.
All right.
We didn't talk about Morrison, but very briefly.
Okay, the very basic point that's critical in understanding, at least when the Ninth Circuit came out in Toshiba, is that what's called an unsponsored ADR program is one that is set up by a bank, a broker-dealer, typically. Bank of New York, JP Morgan, Deutsche Bank, Citi, those are the four major ADR depositories. They can set up a depository receipt program without the involvement of the issuer of the underlying shares. A depository receipt program, an ADR, is really a laundry ticket. There are underlying shares that the bank's custodian owns, typically in the home country. Take Toshiba, Japanese shares, not listed. Toshiba is not listed in the United States. It's listed on the Tokyo Exchange. It's got shares outstanding. They trade in the public market. They are freely tradable. I mean, if you want to buy one, they're not restricted in any way at this point in time, as long as Toshiba is not offering them. If they want to offer them in the United States, we know that that would require registration or typically a private placement exemption. But assuming they're not offering anything and they're just trading out in the market, a bank can say, look, I'm willing to convert yen-denominated shares into a dollar-denominated instrument. If there are dividends paid in yen, I'll convert them to dollars and make it easy for you, the U.S. investor, to have an interest in the Toshiba shares by creating this depository receipt. And let's keep it simple. I'll issue one depository receipt, they're often called depository shares, one ADS, which is represented by a certificate called an ADR. One ADS, let's say, represents one underlying Toshiba share. So the market, you buy one ADR, one ADS. It'll be the dollar equivalent, roughly, of what Toshiba shares are trading for in the Tokyo market. Otherwise, there'll be arbitrage that gets the two to coincide. And you buy that in the over-the-counter market because they're unsponsored. Toshiba does nothing, let's assume, and that's one of the big questions, factual questions in Toshiba, which the Ninth Circuit reversed and remanded. They reversed a dismissal, which we can get into, but they remanded it because they said, hey, district judge, go figure out whether Toshiba had anything really to do with the establishment of this program. Because it seemed like the Ninth Circuit was going in the direction of saying if they had nothing to do with it, then we'll say that whatever they might have falsely said in the public in Tokyo, we're not going to treat that as being in connection with a fraud in the United States. We'll see how that plays out. But again, it was critical that it be, well, maybe critical, I would say critical, that it be an unsponsored ADR program done solely by the bank without Toshiba's involvement, as contrasted with a sponsored ADR program where the issuer of the underlying shares actually signs an agreement with the bank saying, could say, I'll pay some fees, you set this up, I'll cooperate with you. You can't list an ADR program. There are ADR programs that are SEC registered. They were offered publicly under SEC registration. They are listed on NASDAQ and New York Stock Exchange. They have to be sponsored. The exchanges won't let them be listed without them being sponsored, but they can be sponsored and trading over the counter as unsponsored ADRs do. Over the counter means not on exchange. Okay. So Toshiba cert has been requested by Toshiba because Toshiba lost below. Toshiba had gotten dismissal on a Morrison argument, which we can get into briefly. But they convinced the district judge this was really, a Japanese matter, and you ought to dismiss under Morrison. The Ninth Circuit said, not so fast. We think it really could depend on how much involvement Toshiba had in setting this up. That's a factual question. We remand for that, but meanwhile, we'll reverse the dismissal and see what happens. Toshiba sought a Supreme Court review. Cert is pending. The Supreme Court has asked the Solicitor General to weigh in on whether the Solicitor General believes cert is appropriate. And that's where that stands. So they haven't granted it or denied it. They're waiting for the Solicitor General to weigh in on cert. Okay. I started the slides, and if what I say doesn't match what I'm not looking at, you'll wave and I'll look around and figure out what I'm too many pushes. I thought it was useful to start out laying out just background, preface, before I get to the actual cases in detail, lay out what are expressed private rights of action, which is on slide 2, and I think they're self-explanatory. What are expressed private rights of action under the Exchange Act? Again, self-explanatory. The reason, which I think quietly you ought to think about, however you have access to these slides later, is to compare and contrast the terms of implied rights of action and express rights of action. One, I think the best example, very quickly, is 10b, section 10b, where there's an implied right of action that the Supreme Court has long found. There was an implied right of action, that's ages ago. It requires scienter, because the Supreme Court concluded it speaks in fraud. But if you compare the express private right of action for false statements under Section 18 of the Exchange Act, which is based on a false statement, with 10b, it's interesting. On the one hand, it doesn't require as you'll see on slide 3. As you see in slide 3, that applies to any filings with the SEC. So 10Ks, 20Fs, 10Qs, 8Ks, not Form 6K. Again, I don't know to what level of detail you've ever had to gotten to what requirements a foreign private issuer has when it becomes subject to Exchange Act reporting, because it lists in the United States or does a public offering in the United States of equity, but or of debt for that matter. But one of the requirements of a foreign private issuer is that it must annually file a Form 20F. That's a filing, and then it must report on a Form 6K any material developments that they've otherwise made public. So they're not required to just disclose material developments. That would be way beyond the reporting scheme for U.S. companies here, which is, as you know, there are some short triggers under Form 8K, whatever, X number of items that if they happen, you got 4 business days to put that in the 8K, but there are many things that would be viewed as material that don't trigger an 8K, and that generally are caught up in the quarterly 10Qs. So the 6K is, on the one hand, a foreign private issuer should promptly tell the world in the United States, in an Edgar filing, in that sense, something that goes on the Edgar record, you got to catch us up. I mean, you put out something out in your home country, it's public out there, you got to tell, and it's material, you at least ought to tell the U.S. market. But that 6K is not deemed to be a filing, and it's not subject to Section 18 liability. A little quirky thing. But Section 18, again, the express private right of action, Section 18 differs from the implied private right of action under 10b, different level of intent. Scienter required in the implied private right of action, whereas there's an affirmative defense of good faith and lack of knowledge. So it's less needs to be shown under Section 18. But the critical point, and the reason you never see Section 18 cases brought, or almost never, is that you need what's often called eyeball reliance. You need to bear the burden of proof that you saw, you the plaintiff actually saw the misleading statement. The underpinnings for a class action, which you may or may not know, hopefully you know, a B3 class action is that you have common issues that predominate over individual issues. A critical issue in a 10b-5 case is reliance. Private right of action requires the plaintiff to establish that it relied on the false statements. But there's a doctrine that has been developed in the courts called fraud on the market, which allows a presumption that anyone in the market, in effect, relied on the false statement if it's a market that is liquid enough so there's reason to believe that information that's put in the market is adequately disseminated and affects the price. So if the company is alleged to have lied about the value of the company and the stock is therefore higher than it should have been, the presumption is even though the class never saw the alleged false statement, the fact that the market was liquid enough to translate information filed with the SEC generally is enough to establish reliance for a class action. That wouldn't work for Section 18. You actually need to say you've seen it. So class actions being, not to gun jump on my mandatory arbitration discussion, but class actions being the way in which the private bar makes money off of claims that they'd like to bring as a class, where they can aggregate damages. If you can't bring a class action, you're rarely going to injure someone. Now, I say rarely. There are now big institutional investors, pension funds and the like, that have enough skin in the game on their own investment that they could probably bring actions if they wanted to alone, but you rarely see a Section 18 action. So there's no implied private right of action under the Securities Act. The express ones are given in the earlier pages. For misstatements, it's Section 11 and Section 12A2. There is another one, 12A1, that deals with a failure to register when you're supposed to, violation of Section 5 of the 33 Act. But you don't need, no one's ever sought an implied private right under the 33 Act. Under the Exchange Act, as I said, is 10B and Rule 10B-5. And critical to looking at that, in addition to the distinction I was just talking about between Section 18 and 10B and 10B-5. Other distinctions that are crucial when you think about 10B-5 and that come up in Lorenzo are two. One, you don't have an implied right of action for aiding and abetting. The SEC can bring a cause of action for aiding and abetting. So what's aiding and abetting? Somebody deceived you face to face. Boom, they lied to you. But the way they lied to you is producing a piece of paper that included maybe a legal opinion. But the lawyers, they gave the opinion. They didn't go out to market the thing. They're behind the scenes. The question is, did they do something that was part of, that the investor, the aggrieved investor, can say, wait a minute, that lawyer is the one who tricked me. And the courts have wrestled with whether, in that situation, the liability is primary, the violator, there was a violation by the defendant because they made the false statement, or no, not so fast, they didn't make the false statement. They helped somebody who did, but they didn't actually make it themselves. So, big important point. Lorenzo, the significance of Lorenzo is very much because the question before the court was, if I've got a false statement, which is covered by Clause B of Rule 10b-5, if that's the only primary violation I can allege, the folks behind the scenes cannot be sued privately. SEC can go after them under aiding and abetting, and I have a slide that describes aiding and abetting, kind of knowing facilitation of the primary violation, but you can't sue them privately. And there's a couple of Supreme Court cases. Denver Bank is the leading one. The first one is another case, Stone Ridge, that go into the fact that certainly the conservative justices on the court just kept saying, nope, we wouldn't extend the private right that far. The other thing, very quickly, to focus on, on slide 4 with respect to 10b, that is dealt with in Lorenzo, is really the core of Lorenzo, is there are 3 clauses in Rule 10b-5. Clauses A and C basically talk about employing schemes or engaging in acts and practices that operate as a fraud. They sound in fraud, no question, but they're conduct related. Clause B is making a false statement, a material false statement. And the making point is what led Justice Thomas, in an opinion you might question, but it's great for the defense bar, in a case called Janus, and I'll talk about it later when I talk about Lorenzo, J-A-N-U-S, Janus, a big mutual fund complex, and basically, it's a crazy case, but basically the mutual fund was the one who was the entity sued. The manager, the investment advisor, was sued. The investment advisor said, hey, I never said those things. My mutual fund said it. But says somebody, but says the plaintiff, you are the mutual fund. Mutual fund has no employees. You wrote it. You did everything. I know, but my name is not there as such. I didn't do anything. And I don't remember, it was a 5-4 or whatever, but it was a then conservative liberal divide. Justice Thomas wrote the opinion in Janus saying you need to be the maker of the statement to have primary liability under 10b-5b. It turns on who made the statement. And there was a little bit of back and forth as to how do you decide who made the statement, but ultimately in Lorenzo, I'll talk about it, they made clear that the person, the entity that has ultimate authority over the contents of the statement should be viewed as having made it. And that's the only person which will have, as a defendant, primary liability and subject to a private right of action under 10b-5. Could be subject to an aiding and abetting claim by the SEC, or maybe a control person claim, potentially. And that could be brought privately. But you need a predicate primary violation for either aiding and abetting or control person liability. And so the first question is, what's my primary violation? Janus says, under B, only the person who has the ultimate authority can be brought as can be held to be primary violator. The other provision here I discussed is section 14A and 14A9. They relate to misleading statements in proxy solicitation material. And what's critical about that when we get to Emulex is the question whether there should be a parity of treatment of 14A, which is material misstatements or omissions in proxy solicitations, and tender offer statements. The argument being they're both often used to accomplish a takeover. So why should they be treated differently? And I'll wait till we get to Emulex to go into the arguments back and forth, but that's why it's important. Right now, there is a private right of action under 14A, a 1964 Supreme Court case, J.I. Case v. Borak, so held expressly, as I'll explain in the Emulex argument. It was clear, like beyond peradventure, that at least the conservative justices said, never again, that was not right. Back in it was a 64 case. Back in 75 in Court v. Ash, we said the court just can't go poking around and creating implied private rights. Congress has to be much more affirmative in saying they intend something, a provision they enact in a statute to give a private right. That was repeated again in a 2000 case, Sandoval. In any event, the conservative justices were all over the fact that we wouldn't do it again, for sure. Roberts in particular doesn't like to overrule too often. He likes to recognize stare decisis when possible, and it wasn't before them. The 14A case per se wasn't before them. What they do for what ought to be arguably a parallel situation in 14E, we shall see, and I'll talk about it more. So that's 14E. Let's go to the SEC actions. And again, very quickly, 17A, it's in the 33 Act, as I said. One of the things, coincidentally, I got focused on this morning when somebody asked me a question, we discussed it, is that in fact, 17A focuses on offers and sales. Compare that in one respect to 10b-5, which is purchases and sales. If you don't have a purchase, if you didn't actually trick the person into actually buying, you tried to but just failed, that person can't bring a 10b-5 case because they didn't purchase. Let's assume you tried to purchase. You tried, you lied, it didn't work, sorry, no 10b-5 case. SEC can bring an action under 17A against that person because they offered in a manner that violates the law with a misstatement, let's say. So that's kind of interesting. On the other hand, what came clear today as we were talking about it is that the SEC itself acknowledges that they don't have 17A if they're going after a company in what I'll call a stock drop case. Company's not offering its securities, not privately, not publicly, but it's alleged to have made a false statement to the market. That's not the SEC doesn't have authority under 17A. 17A focuses on misstatements made in the context of an offering. It could be a public offering, it could be a private offering, but there's got to be an offering going on. The other thing I would note right now very quickly is if you look at Clause 2 of 17A, the language it uses, unlike 10B, which is similar but not the same, 10b-5b, 10b-5b says if you make a false statement, you've got liability. 17A2 says if you obtain money or property by means of the use of a false statement. So, all of a sudden the Janus case, which says, gotta be a maker, SEC says, I don't care who made it. Did you use a false statement to get money? And indeed, under SEC v. Aaron, negligence is sufficient under 17A2 at least, for sure, for the SEC to get an action, a successful action against someone who offers or sells. And so that's interesting too, by way of difference. 10b-5 obviously, we know, I mean the SEC requires, the most interesting thing that I get involved with counseling clients with the SEC and its use of 10b is it does not have to prove reliance. Private actions do, SEC does not. There's another key element of 10b that it doesn't have to prove. Maybe it's something to do with the loss causation issue, but I'm going to stop. If I open my mouth too much, I'll tell you things that are not right. I'll tell you only things that I'm absolutely certain are right. Or Doug or you'll correct me. Under 10b, SEC action 10b, you don't prove reliance, which has interesting ramifications because there are things called big boy letters. I don't know if you ever get into things called big boy letters. So big boy letters, there are two ways the term big boy letter is used. It's a term in which somebody says, I want to sell you a security. I want you to say that you haven't relied on me when I've tried to sell you the security. You've made your own investment decision. You had all the access to diligence you needed. You didn't rely on me. I brought it to your attention, but you made your own investment decision. If you can establish that, then you've made it impossible for the buyer with what's often called buyer's remorse. They bought it, oops, value went down, who the hell can I sue? Well, you can't sue me because you've made it clear, you signed a piece of paper acknowledging that you didn't rely on me, and, it's important, and the facts bear out that you had the ability to make your own decision, investment decision, you had access to all the information you needed, you didn't need to rely on me. Because very critically, I know I'm giving you a lot of information and tough luck, you write it down and you think about it later. There is a provision in the Exchange Act and a parallel provision in the Securities Act, and this too will come up with the mandatory individual arbitration discussion if we ever get there. And that is those provisions, 29A of the Exchange Act and section, I think it's 15 of the 15 of the 33 Act. They say the identical thing. They say advance waivers of the protections of these statutes are not enforceable. So, if somebody, it's like when you do skydiving, or any other dangerous exercise, and they ask you to sign, a waiver that waives everything under the sun. You'll say, sure, let me sign it, and then you'll quietly say, yeah, but if I ever have to force it, I'll say it's unconscionable, and it was not really a meaningful discussion. Who knows? Hopefully you'll never have to worry about it, because it probably will be your heirs that will have to argue if you're skydiving and the parachute doesn't open. But that's a separate issue. On the other hand, the big boy letter I just described, if you just get somebody to sign and say, oh yeah, I didn't rely on you, but they in fact did no diligence, didn't have access to due diligence. They could decide not to do it. They didn't even have access. And essentially, they had to have relied on you because they didn't have any other source of information. Then when they have buyer's remorse and sue you, and you say, oh, but you said, you signed a piece of paper and said you didn't rely, the response is going to be, oh, but that's an unenforceable advance waiver. So, facts and circumstances, you figure out which. There is a separate use of the big boy letter, which I try to convince my clients never to do, where they say, oh, we have material non-public information. We have inside information. We want to get you to confirm that you don't have a level playing field. You don't have the information I got. You're still willing to invest. If that is and again, I'm not getting into 10b-5 from the standpoint of its use to deal with insider trading. It's a whole separate topic. But as you may know, it is not just, and Judge Rakoff, I just read something where Rakoff criticized, I think, a jury instruction or something where the prosecutors, I think, wanted to say, oh, the market's a level playing field. The answer is it's not a level playing field in the United States. 10b-5 requires a fraud. It requires either a breach of fiduciary duty or a misappropriation of information in order to have a predicate violation that then allows somebody to claim that insider trading took place. The SEC doesn't necessarily have that problem, or insofar as they do, they actually do, sorry, I'll take it back. They have that same issue to worry about. They've got some rules to make it easier for them to try to assert a claim. But insofar as somebody says, well, you didn't rely on me, because you signed a letter saying you knew I had non-public information, material non-public information, you decided to buy anyway. And so if you bring a private action against me, I'm going to try to argue that you didn't rely, and therefore you lose, and then that'll be met with this 29A, no, but it's unenforceable. Vis-a-vis the SEC, the effort to say, hey, they didn't rely on me doesn't work. The SEC does not have to prove reliance. So these big boy letters are only trouble. The SEC has occasionally criticized them. They're only trouble insofar as you're dealing with inside information. So far as you want to get a confirmation that the investor didn't rely, that's fine, but better make sure it's consistent with the facts. All right, much too much said. We'll talk about 14A and 14E and the SEC's ability to bring claims on basic negligence when we talk about Emulex. So let me keep going. I don't think there's anything. Secondary liability, when I was putting this together, I thought it was kind of interesting. The secondary liability can actually be broken down into two pieces. Maybe it's nomenclature. Controlled person liability, which there is a implied private right to bring. You need a predicate primary violator. Classic case, the company has made false statements. It's found to be liable under 10B in a private action. You can go after the CEO. You can go after people who control the company. Now, they have a defense that they didn't have actual knowledge. In the Exchange Act context, a little different than the 33 Act context. The affirmative defense is, hey, I acted in good faith and I didn't induce the violation. I'm the CEO, I didn't know about any of this stuff. Anyway, there are other ways to try to get at a CEO maybe, but I'm not here to do that. So in any event, that's control person liability, a form of secondary liability. The other form of secondary liability is aiding and abetting. And again, we've talked some about that. It is available to the SEC. There's no implied proper right of action for it. So let's go to Lorenzo. Lorenzo, as I said, 6-2 decision. Interesting that Alito and Roberts joined the four liberals in finding that, first they affirmed that, interesting, they affirmed the DC Circuit decision, which was unanimous, Kavanaugh agreed with this, that Lorenzo did not violate 10b-5b. Let me briefly describe the facts. Lorenzo, it's a small investment bank. Lorenzo was the head of investment banking for this investment bank, little investment bank, never heard of it. And the owner may have been called Lorenzo too. But anyway, it doesn't matter. Lorenzo, the defendant Lorenzo, was the head of investment banking. Lorenzo sent an email to his clients saying, great investment, there's a private placement going on of debt, which they were trying to arrange, this investment bank. He says, great company, go buy it. When he did, it was back and forth. This again, an SEC action. So it went through an administrative law judge, SEC then concluded the administrative law judge's finding. The administrative law judge and the SEC both found that Lorenzo violated A, B, and C of 10b. Lorenzo challenged that in DC Circuit by saying I didn't violate 10b-5b because I didn't control the statement. I didn't have ultimate authority. Why? Because my boss told me I had to do it. He wrote it. He basically said, hey, Lorenzo, you go send it over your name, which says at the bottom, head of investment banking. The email also said, hey, if you have any questions, call me. Call me Lorenzo. But, says Lorenzo, I did this because my boss told me to. I didn't write the line. Back and forth as to whether or not Lorenzo knew that the statement was false, but there was a finding below that he did. He didn't really contest that. So there was scienter on the part of Lorenzo. He knowingly disseminated the false statement. Everyone agreed, the DC Circuit agreed, and it was not appealed. SC didn't appeal it smartly, because who knows what would happen. Anyway, not appealed, didn't violate 10b-5b, so they reversed the commission. You didn't violate 10b-5b. Then the question was, could you violate A and C? A and C are fraud issues, but they're scienter. If you disseminate a false statement, does that have liability, create liability under A and C? Scheme, conduct kind of thing. Conduct, your conduct was bad. Or is it just an end around this Janus decision, which said, if you didn't make the statement, you can't be held liable. And A, B, and C must be treated, you can't not violate, it's kind of, I don't know, there's some lovely Latin phrase about, specific trumping general, that kind of thing. So, insofar as 10b-5 focuses on use of statements, 10b-5b is the right provision to look to. And I'm trying to do this because I actually think the majority is right here. But anyway, majority said, look, this guy knew he was disseminating a false statement. We are not comfortable that he might be found not to be primarily liable. And then they can't even be aiding and abetting liability. Because even though the SEC can bring an aiding and abetting case, they can't bring it against somebody if there's no primary violation. So to avoid that kind of loophole, this kind of the feeling you got when you read the case, the majority, including, as I say, Alito and Roberts, held that all three provisions needed, they could overlap. The idea that B is the only applicable provision when it deals with the use of a misstatement is not right. It's all a big bundle of stuff, and if conduct is bad, that's enough. And as I say, so Janus, I'd say Justice Thomas wrote Janus. You can imagine he was getting a little upset that you were circumventing his decision. And Kavanaugh seemed to go with that, but recused himself. And Gorsuch, as I said, I'm shocked that Gorsuch and Alito parted company. I thought they talked to each other about the same way, but you never know. You never know. So that, I think the main takeaway from Lorenzo, for me, is, well, there's two things. One, having clerked a long time ago, Second Circuit, I like to, you read opinion, you think about what is, who missed what and who should be shot. I was surprised in the majority decision, there was a sentence put in there. Breyer wrote the decision. The decision, in the opinion, he stuck in a quote from Denver Bank. Now, Denver Bank did hold no aiding and abetting, but he basically picked up a quote, something along the lines of that even a bit small participant in the securities markets may be liable as a primary violator under 10b-5 so long as all of the requirements for primary liability are met. Now, there's a circular field to that statement. But what was annoying about it, from the defense bar standpoint, is kind of suggests that, maybe a bit player could be held liable under A and C as primary violators, even though they clearly didn't make the statements. I don't think that's what the facts support, so I'd say dicta if I was arguing. And the court very clearly thought it was important that Lorenzo, first of all, clearly disseminated the statement, no doubt about that. People knew that, and they got his email. Okay, so it wasn't that they got a document from somebody, didn't know who it was. They got it from Lorenzo. He was the head of investment banking. The best contrast, and the dissent tried to make a lot of this. I don't think the majority would have disagreed if the facts were different. But so the dissent says, well, I mean, if a secretary sends out a statement and knows it's false, sends it out because her boss said to do it, that's enough for liability. And the court said, look, this isn't even a close case. This guy was head of investment banking. He said, if you have any questions, come back to me. We think he added meaningfully, and this is my words, added meaningfully to the false statement itself by being the disseminator. And where it can be very important is there's been uncertainty.
question.
Oh my God, really? You want to interrupt my mom?
Yes.
Sure, go ahead. So,
Supposing an associated investment bank, knowing it was false,
Mhm.
the investment was safe, not a second. What's your view?
sends it out over his name.
Yeah.
I guess I would suggest they not do it.
No, let's
My
say-
advice before the fact
No, no.
is
He
do not
did.
do
The
that.
fact is he did it.
You know, I
How
think.
do you defend him?
One of the, well, I mean, I would say that there's not enough credence being given to the fact that he said it, but it's a close question. There's no question about it. I think the real practical takeaway for this case, when Janice came out, defense bar was trying.
That's crazy.
What?
It's a crazy case.
Well, all right, but where the rubber could hit the road here, and we didn't put this in our alert memo because I don't really want to make it easy for the plaintiff's bar. And the people who are plaintiff's bar here, please leave or cover your ears. But it may be possible, I would be easily able to defend it, but may be possible to take Lorenzo in your classic capital markets transaction. So you've got an issuer selling securities through underwriters, has a prospectus or an offering document, if it's a private placement, that has a couple of things. First, it says in the front, hey, these are the company statements, they're not the underwriter statements, please remember that. On the other hand, on the front cover are the names of the banks, and they are the ones calling investors to sell the security. The question is, if they knew the statements were false, very unlikely, at least not any banks that I deal with, but more possible, they are found in hindsight to be reckless, which, again, reckless, there's a Sunstrand case, 7th Circuit says reckless is an extreme departure from the norm. And I say extreme. So, what does it take to be reckless within the meaning of 10b-5? I'd say it takes virtual, I closed my eyes kind of thing. There were red flags, they were really red. There's a horrible case, WorldCom, in which Judge Cote found red flags in hindsight that were absurd, but that's the risk you take. That is a risk a bank takes. So why do banks, even when they do private placements under a rule called Rule 144A, not SC registered deals, where SC registered deals, Section 11, noted in the slides, there is an affirmative defense of diligence, but plaintiff doesn't have to prove that. Plaintiff just says, there's a mistake, material misstatement here, or an omission, and now it's up to the defendant bank to say, oh, wait a minute, here's all the things I did, that's a good diligence defense. And in a registered deal, there's no question what they will do. They'll get letters from counsel about the accuracy of the information, broadly speaking. They'll get a comfort letter from accountants. They will do diligence. They will talk to people, depending if it's an IPO, they'll do diligence with vendors and all that. If it's a repeat issuer, they'll do less, but they'll still do diligence. Okay. The question, way back in 95-ish or so, Supreme Court decided a case called Gustafson v. Alloy, surprisingly, the Supreme Court said, in a private placement, you don't have 12A2 liability, another one of those express cause of action I mentioned in the slides. You don't have 12A2 liability. If you had 12A2 liability in a private placement, then you would have a question of then I have a reasonable care defense, but I have to assert it. Again, it's not strict liability, but the seller must show that it had performed reasonably, exercised reasonable care in confirming the information it used to sell the security. The Supreme Court said in, I think it was 95, no, we the Supreme Court don't think a private placement is a public offering. That was easy. And we think, more interestingly, that 12A2 only covers public offerings. So after that, everyone said, well, does that mean if you do a private placement, you don't have to worry about doing all that diligence stuff? And the answer the bar gave, it was a bit self-serving, but it was also, I think, good advice. And now even more so. You ought to do the same panoply of things you do in a registered deal. Maybe not in an IPO, but at least in a registered deal. Get letters from counsel. Get a comfort letter. Talk to the issuer. Read the documents, obviously, and think about red flags, inconsistencies like. Why? Because you want to have a strong argument, maybe even a summary judgment strong argument, that you were not reckless. And if you can do that, then you can get out from under, let's say, maybe even on summary judgment. All right. So I think that's Lorenzo. Let's go to Ambulex. I should say, if anyone else has questions, by all means, feel free to interrupt. Cool.
Quick question. So do you think, is there any reason to think that Lorenzo's reasoning doesn't apply to Section 18?
Of 34?
Correct.
Well, there, if I remember right, 18 says the document has to have a misstatement. So I'm not sure you get into, it's really going to be against the company. I think 18 is principally a claim against the filer of the statement.
It's typically against the maker, so I'm just wondering if it's...
Well, yeah, the maker in an SEC filing will be the company.
Right. Does it have the same kind of... I forget the statute myself.
Well, the reason you do is nobody brings cases on it.
Right.
They really don't, because you can't get easily class actions on it, and so they don't bring.
Right.
They'll bring 10b-5 instead.
No, but institutional investors bring...
What's that?
Institutional investors bring up that claim.
Yeah, but I don't see much Section 18 stuff. So the short answer is, I think if the company's made the filing, you're going to go after the company, you get control, you go after their control persons, make life miserable. There's no aiding and abetting private right there, I don't think. It's not expressed there. And so then there's the affirmative defense. But I don't think you get into, the Lorenzo case really goes to whether third parties who didn't make the statement could be held liable as primary violators under A and C. I don't think it comes up in 18. So Emulex. Yeah, as I say, the first bullet should read now, cert granted, case argued on Monday, April 15th. So there it is. The background very quickly is Ninth Circuit reversed a dismissal below. The dismissal was based on the fact that under 14E, no one challenged the private right of action, but it was seemed to be received wisdom, 5 circuits had held, Supreme Court had never touched it, that you need to have scienter. And you could, maybe way back when that could have been different, but it was pretty clear 5 circuits said scienter. They kind of looked at it and said, hey, it looks like 10b-5 must be, should be treated like 10b-5. Interestingly, they didn't think, I didn't go back and read the circuit cases that found scienter being required, and so life's too short to do everything in this regard. So I don't remember how they dealt with what is probably the strongest argument for negligence, which is 14E ought to be in parallel to 14A. And 14A, there are some circuits, and the majority of circuits have held negligence is sufficient for 14A. Sixth Circuit said, no, we think a scienter is required. Supreme Court has never passed on the level of intent required, if intent is required. Yes, passed in Borak that it's private right, but not the contours in that sense. Anyway, district judge looks at 5 circuits, says, hey, everyone's saying scienter, you didn't plead scienter, well, dismissed. Ninth Circuit, unanimously, if I remember, said, wait a minute, we think it ought to be negligence. And they were persuaded by the 14A analogy, a level playing field with 14A. Why would Congress have intended to treat proxy solicitations differently than tender offers? They're both trying to result in acquisitions of companies. Often, proxy solicitations cover lots of other things, but insofar as tender offers are focused on takeovers, so are proxy statements. And I think, in fact, in the oral argument, many more proxy statements, there are many more proxy statements than tender offers. So in terms of burden of review and the like, which came up a little bit, in terms of does the SEC need the help of the private bar to enforce, there was a view, it seemed to be, it wasn't, it was, I don't know, I thought it was fairly loosely discussed, but there was a feeling that you could make the argument that the SEC could use the help in, more so in the 14A context than the 14A context. In any event, they assumed there was a private right of action in the Ninth Circuit, but said, hey, we reverse because we think negligence is sufficient. District court, go have a trial on negligence. Cert was sought and granted by Emulex, the defendant and appellant, and Supreme Court decision, as I indicate, and the argument pretty much dealt with things like this, thankfully. There is this point first one I mentioned, aptly says, hey, you know what, 14A, well, 14E should be the same. As I say, I did a little digging, and it was clear on the one hand that Borak, as indicated in the next bullet, certainly held clearly for a private right by the Supreme Court in 1964, but it didn't deal with negligence. It didn't deal with the level of Siena versus negligence, and there's no Supreme Court case that has. In the circuit level, majority circuits have said negligence is enough. 6 has said Siena is required. But critically, if the Supreme Court wants to reverse, which I think they will, I don't think they clearly don't have to overrule a prior Supreme Court holding that negligence is sufficient under 14E, because they've never ruled on whether 14E has a private right of action, and therefore obviously they haven't ruled on what the contours of it would be. So Pelley's strongest argument was probably parity 14A, 14E. A second argument the appellee made that I didn't list here, but that was made in oral argument, is if you look at the Litigation Reform Act, it was around 1995, Private Securities Litigation Reform Act, it provides a safe harbor for forward-looking statements and says if you provide appropriate cautionary statements that surround it, then those cautionary statements make things okay. You're not liable if it turns out your prediction was wrong. Is essentially what it's saying. And interestingly, in the Litigation Reform Act, it says, look, we're creating the safe harbor in private rights of action. And they list a bunch. And then they say, except for a couple of types of private rights of action, one of which was tenable. So the appellee says, hey, look, Congress in '95 seemed to assume that there's a private right of action. How much weight to give that, I don't know, but it's some weight. Another thing that came up in the argument that I didn't realize, but I didn't exhaustively read the briefs, I glanced at it. In the argument, front and center actually was, and actually the liberal justices were banging on this, and they said to the appellant, hey, look, you didn't raise this no private right of action. Forget the negligence. The other point, as I said earlier, the whole question was a private right of action. You didn't even raise that until you sought rehearing in the Ninth Circuit. So you didn't raise it before the panel. They didn't have a chance to pass on it. We think the Supreme Court, it would be improvident for the Supreme Court to weigh in that situation. The appellant said, well, wait a minute, in the Denver Bank case, so the Supreme Court actually sua sponte raised whether there should be private right of action in aiding and abetting. It wasn't even raised in the briefs. So come on, there isn't a procedural bar to my raising this at rehearing. And they went back and forth some, and I think my view is, the bottom line, my view is that even though the methodology for implying private rights of action, the analytical underpinnings of that, was so clearly in the minds of at least the majority of justices now, the 5 conservatives, so clearly changed and narrowed in a couple of cases, Court v. Ash and Alexander v. Sandoval, subsequent to Borak. Much tighter. We're not going to just think, oh, yay, Congress thinks this is bad. They must think it would be better if it was enforceable privately as well as publicly by the SEC. We're going to need some more evidence that Congress wanted it to be enforced privately, and absent that, we're not going to apply a private right. And they said, hey, if we had Borak today, we wouldn't do it now.
Did the Solicitor General participate in
Yes, they did. I'll get to that.
Because in Borak, didn't the SEC take the position that we needed private
Oh, sure.
attorneys general?
Oh, sure. Well, guess what? Solicitor General says, Solicitor General came in and selfishly, in a way, said, forget the private right. We don't give a damn about private right. What we care about is that you interpret 14E to allow us, the SEC, to do it on negligence. We're not stuck with Siena as the SEC. Private right? Who gives a damn about that? Literally, I mean, it was a woman who was arguing for the SG's office and just kept saying it over and over again. Not that we don't care. We think this is a perfectly nice argument. There is no private right. But we kind of don't have skin in that game. All we want to be sure of is you preserve negligence for us. Anyway, I think it's going to come out. I think the combination of a little procedural thing, which might be just a hook, the little Litigation Reform Act, which I thought was kind of interesting evidence that you could point to if you wanted to. I think that the 5-judge justice majority conservatives who would normally say, and did say, we're never going to imply private rights the way they did in '64. I think Roberts in particular will not reach out to sub silentio overrule Borak and a whole line of 10b-5 cases and 14e cases. I think the posture is going to be let it be private right, let it be with Siena. We'll see, but we'll see.
For both the SEC and the...
What's that?
That will be the standard in your opinion, both the SEC actions.
No, I think they'll just the way
Or
inherent,
the SEC
just the way
follow
there's a
the
dichotomy between 10b-5 and 17a2. So no private right of action under 17a. SEC, you can do it with negligence.
Under error.
Right. I think that's how they're going to cut it. But again, they don't have to say what the standard for the SEC is. It's not before them. So they might not say anything. They might simply say we think it's private right, and as to the SEC, we'll decide that. We'll decide that if it ever comes up, and we think it needs to. Or they may give a nod. As I say, I think the better view would be there is a private right. I'm sorry, there is authority in the SEC to bring the action, and there's enough basis to argue for negligence that the court would allow that. And finally, Stoyas versus Toshiba. I did some, I think, sufficient background explanation, unsponsored ADRs. The argument gets very interesting about Stoyas versus Toshiba. So Toshiba has had a big mess, to use a technical term. They bought Westinghouse. Westinghouse had whole problems with nuclear reactors or whatever. It went down the tubes. That took Toshiba down pretty far. Didn't quite put them in bankruptcy, but pretty far. They didn't bother to recognize that for a long time. So pretty easy to say that they held back from the market information, and they were bad in that sense. But they didn't offer their securities in the United States, or at least they may have, and that's a separate case. The case that was brought, that we are dealing with, is a case brought by a putative class. Class termination hasn't been held yet, but a putative class action claiming that we bought these unsponsored ADRs in the U.S. over-the-counter market, and we therefore have, under the Morrison parlance, we have a domestic transaction. There's no question. Again, can I assume knowledge of Morrison? Okay. So, I mean, Morrison is a great example of why dicta is treated appropriately as dicta, because Morrison, so-called FQ case, foreign plaintiff, foreign defendant, foreign exchange. It was foreign. And it was easy for Justice Scalia maybe to show off and put friendly down. That's a separate personal point that we might get to briefly. But in any event, it was easy for him to say, no, I want a nice, simple 33 Act, 34 Act, frankly, all of these statutes, Commodity Exchange Act, although he only dealt with the Exchange Act, he dealt with the 10B case. But in the context of that case, it was easy to say everything was abroad. And I don't think the statute provides for extraterritorial application. So I dismiss. Judge Friendly, great guy, maybe crazy test, conduct effects, so mushy, gushy. Who needs that? Who needs all facts and who knows what, can't predict it. So I want a nice, simple test. It's got to be a transaction on an exchange, U.S. exchange, or in the U.S. over-the-counter market, essentially. If it's transaction outside, focusing really on the Australian Stock Exchange, which is where the plaintiffs had bought their securities, easy peasy. That's not in the United States. So what are we doing here? Okay. That was Morrison. But now Morrison has been extended over time pretty quickly to apply beyond the Exchange Act to all of the statutes in the securities regime, including the CFTC, Commodity Exchange Act, criminal, civil, you name it. It generally, SEC, DOJ, private actions, all under Morrison, this domestic transaction point. And again, they go beyond, the cases go beyond the FQ into situations where there are even U.S. investors. U.S. investor goes to his broker, this is a district court case, goes to his broker in Credit Suisse, says to Credit Suisse in, I'll say New York, somewhere in the United States, buy me some Credit Suisse shares. Broker buys them on the market in Switzerland. Clearly that's where he bought them. Then there's a lawsuit brought, I think maybe against him for misleading her. I can't remember if it was him or Credit Suisse in a sense. But court said, wait a minute, district court said, wait a minute, it wasn't appealed. That transaction was in a foreign exchange. Easy peasy, Morrison. Not a domestic transaction, goodbye. Dismissed. So, the tough issues that we now see bubbling up that Morrison didn't have to deal with. So the first one is in Park Central. And Park Central dealt with an interesting case. I'm already running out of time, but I'll keep going very quickly. So Park Central, Second Circuit case, involved what are called total return swaps, which is in the nomenclature of the 34 Act, a securities-based swap. It's covered by 10b as if it's a security like a share of stock. A bunch of U.S. hedge funds were induced to enter into total return swaps in the United States, which said basically, we will get returns based on, or losses. We will get gains or losses depending on the movement of the underlying shares, which were Volkswagen shares, in the German market. They bought these things, so it's a derivative. It's an indirect economic play off of Volkswagen shares. They only trade in Frankfurt. But these derivatives were signed in the United States. So I think it was Judge Sand below. I remember that, I think, because he was the first clerk for Irving Kaufman, who I clerked for many, many years later. But anyway, it's a tough case because it's a domestic transaction. And so on the Morrison, sounds like you're kaput. But Sand didn't like it, and he said, you know what, this is really, in form, there's a transaction in the United States, but in substance, it's just a laundry ticket to buying the stock in Frankfurt. I'm going to conclude it's not really a domestic transaction, and I'm going to apply the Morrison concept and dismiss. Second Circuit affirms unanimously, 3-judge panel, per curiam opinion, if I remember. But Judge Laval, Pierre Laval, one of the 3 judges, wrote a concurrence. Interestingly, for what it's worth, Pierre Laval, who had been a partner at Cleary before he went on the bench, was a law clerk to Judge Friendly. Some reason to think that he wrote his concurrence to kind of defend the honor of Judge Friendly. Seriously. I know you smile, but I actually think there's something to it. Because he basically, if you read his concurrence, he says, you know, the idea that it's all simple, easy peasy, bright line, the world's not built that way. What you really need to understand Morrison, at least when you apply it downstream, so it's not the simple F cubed case that you're talking about, but it's got some US elements, what you really should do is say, all right, it's necessary that there be a domestic transaction, but that's not sufficient. And then you decide, if you have a predicate domestic transaction, then you decide, in the words of Park Central, is this nevertheless a predominantly foreign matter? You know, the bad guys are all outside the U.S., they spoke outside the United States, the securities trade outside the United States only, that was his decision. And he kind of said, you know, that's kind of context and effects. No, it's kind of facts and circumstances. So that's what he says. Very quickly, we get to the Ninth Circuit. So the Ninth Circuit has a similar situation. Now, it's ADR, so it's not total return swaps. And to some degree, the Ninth Circuit, I don't know, if you read the opinion, I thought it was kind of sophomoric. But maybe it was right for people who weren't that sophisticated in the market, and they went through, and what's an ADR, and blah, 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 and is it different than a total return swap? And it really isn't a lot different in many ways. I mean, you're getting the indirect benefit or detriment of investing in the underlying shares by buying the ADR. So there's a symmetry with, or an analogous circumstance to the Park Central case. Although you could try superficially say, oh, no, that was total return swaps, and we're dealing with ADR, two different things, and so we can come out differently. I don't think that holds water, particularly. We'll see what the Supreme Court does if it takes cert. But Ninth Circuit said, look, we think this Park Central case is crazy. We think it just really ignored the concept of Morrison, which is a simple, bright line. It returns conduct and affects kinds of certain facts and circumstances. We're not going to follow it. What they said, though, thankfully, for the defense bar anyway, is, but that doesn't answer the question either. So we think it's a domestic transaction. We think it passes the Morrison test. We think, therefore, we wouldn't dismiss for lack of jurisdiction an extraterritoriality analysis. What we think the right way to look at this is the fraud in connection with the transaction? Did Toshiba, when it put out its statements in Japan, intend to induce purchases of these ADRs in the United States? Not crazy. And in talking about that, and I write down a few things from the case, it was interesting. Not in their complaint, but in their pleadings, in their oral argument, the plaintiff said, oh, Judge, you got to understand that these ADRs, they may be unsponsored literally, but the company knows it's happening, the company is asked to object, and if they don't object, then it goes forward, so they kind of know, and whatever. They kind of waved their arms, and the judge, the Ninth Circuit said, you know what, that's very interesting, now go assert it in a complaint, in which you're standing up for what you're saying and not just talking in oral argument. And if, you talk about the circumstances and the relationship between Toshiba and this program, then that may cause us to think it was in connection. They intended to induce purchasing in the United States. The one thing they said, which is really good for the defense bar in the world of unsponsored ADRs, is in order to get an unsponsored ADR, you don't need the consent of the company, the issue of the underlying. The SEC made a rule change 5, 8 years ago, whatever, changed it and said the depository bank can set up one of these programs without getting the consent of the underlying issuer, as long as the underlying issuer is complying with a specific exemption from registration of equity under the Exchange Act, or Rule 12G, or Section 12G. What's called Rule 12G through 2B, it's on the next page. So the last page, thankfully. So 12G32B is an exemption that a company can get the benefit of by putting certain documents, its financials, things like that, in English on its website. And the Ninth Circuit went out of its way in a footnote to say if that's all they've done to facilitate the establishment of this unsponsored program, they didn't do anything more, that's not enough. We'll tell you right now, that won't be enough to convince us that they intended to induce U.S. investors. So we'll see what happens with all that.
Do you think the case will end up in the Supreme Court?
I don't know. I think it may be a bit too muddy. I don't know. I'm not sure. I really not. I also don't know what the court will do with it. My instinct is they won't agree with Park Central either. I mean, the liberals might, but I think the conservatives won't. They will defend Scalia's honor. And they will say, no, he wanted a clean domestic transaction, bright line, we think that's right. I think they would agree with the in connection with Hook, though, Ninth Circuit purports to find. The tough question is if you have a sponsored ADR, over-the-counter sponsored ADR, you don't do very much, the company doesn't, but you do sponsor it. Is that ipso facto enough? If it was a predominantly foreign test under Park Central, you could argue, hey, if there's 1% of the market is trading in the United States and 99% is trading in ordinary shares at home, and I don't come in the U.S., I don't do anything other than, stay home and issue, press releases, which obviously are available worldwide. I still didn't intend to induce U.S. investors. It's a harder argument because you sponsor the thing, so it is a harder argument. And with that, I've gotten through it. I'm willing to do a 5 or 10 minute précis on individual mandatory arbitration, but I'm not going to insist anybody stay for that if they don't want to.
Shall we talk about that?
How about a teaser 5 minute?
Fine, teaser 5 minutes. So very, very quickly, I can't speak any more quickly, so there it is. Hal Scott and I, on a committee for capital market regulation, starting in 2006, thought it would be better for the U.S. market if class action litigation risk was not imposed on public companies. And so, and there, you can go in to read the law.
It's really bad for these guys.
What's that?
They've been studying these issues for like a semester. So what you're proposing, now they're supposed to forget all about it?
Well, look, my partners at the firm, the litigators say, what are you, crazy? You're gonna put us out of business? We gotta defend these things. And I say, look, I am doing scholarly work. I am trying to do, pro bono for the good of the United States, capital markets. It would be better. Anyway, you can debate whose ox is gored. I mean, the plaintiff's bar would be the most gored for sure. Second would be the defense bar. But for the good of the world, we think instead of class actions, let the SEC enforce as much as they want. But if the shareholder wants to bring a suit against the company, and it could be under Section 11. It could be under Section 11. Could be under 10b-5. Doesn't matter. It's a suit that claims you, company, defrauded me into becoming a shareholder. Where we say the company's charter, or the original proposal was more shareholder friendly. It said, look, we should allow shareholders to decide by a vote if they want to amend the bylaws to require that they only bring arbitration cases against the company on an individual basis, because they agree with us that would be better for the company to stop throwing away money on settlements and to distract management, and if we got bad guys in management, let the SEC knock them off. That's the policy. So very quickly, the SEC, notwithstanding at least 6 U.S. Supreme Court cases, saying the Federal Arbitration Act, passed in 1925, says that arbitration is a perfectly good forum for vindicating rights under statutes, all kinds of federal statutes, contracts, you name it. It's fine. The SEC has taken on itself to say it's not good public policy. We won't allow mandatory individual arbitration in a charter. And in bylaws, if shareholders have the temerity to propose it, we're going to say, if the company says to us, we want you to exclude that because it would violate the law, we're going to say, okay, says the SEC, and they've done that back in 13. We think that's ridiculous. We think federal law is incredibly clear, couldn't be more clear. So we said, come on. And what happened was Hal Scott personally is a beneficiary of a trust which owns stock in Johnson & Johnson, enough to, you don't need very much, $2,000. You have to hold it for a year. He's got more than that. He says, oh, you know what, I'll bring a shareholder proposal to J&J. I'm entitled to. So he does. J&J decides they don't want to deal with this, so they hire Skadden Arps initially to submit a letter requesting 14A relief. I don't have to include that in my proxy statement. We respond, and again, I use the term we. Cleary Gottlieb is not part of this. I'm interested as an academic matter, but this is Scott's case. And Scott's been doing findings in the submissions. Scott writes a letter back saying, this is ridiculous. The claim was, don't include it because it violates federal law. That was the initial claim by Skadden on behalf of Johnson & Johnson. We said, here's 6 cases. Easy peasy, it's wrong. I mean, there's a case Epic, the most recent one. We just quoted a bunch of language because it was easy. Very quickly after that, where Jersey Council comes in, is that serendipitously, there was a case decided, so unfortunately it's more than a 5-minute crazy. But a Delaware case was decided by the Delaware Chancery Court, Judge Laster, who doesn't seem to get along much with the Supreme Court in Delaware, so we'll see what happens. Decided a case which somewhat touches on what is appropriate for a Delaware company's charter or bylaws. What kind of provision, what kind of subject matter is appropriate? Laster said unequivocally it has to be a matter of Delaware law. Can't be a matter of federal law in the context of the case he decided. So all of a sudden, Scott goes, ooh, look at that. We'll come back and say, you know what, in addition to federal law, this would violate Jersey law. And they get Lowenstein's opinion saying the same thing, but both the Lowenstein opinion and the Skadden letter say there is no Jersey law on this. We agree, no Jersey law on this. Other than the fact that a charter or bylaw is a contract, it would fit the Federal Arbitration Act contract.
And New Jersey courts frequently follow Delaware precedent.
But I would say no Jersey law, but
yeah.
Delaware, and I don't disagree.
But Scavacucci is only a chancery division.
Not only that, it's wrongly decided. I would be delighted over drinks to explain so unequivocally why that was wrongly decided. Anyway, Delaware law, we follow it. Chancery decision saying, gotta be a Delaware law case in order to have it in your charter or bylaws, and boom, and Lowenstein, no, he said the same thing, he said, follow that, whatever. We came back and said, again, royal we, Scott came back and said, look, there's a burden of proof here that the company has to have. How, there's no Jersey law. There's a Delaware Chancery case, which we think is wrongly decided for these reasons. That's not enough to meet the burden of proof that it violates state law. Before the ink was dry on that response,
Something more comes up.
yes, the New Jersey Attorney General, out of the blue, puts in a letter to the SEC saying, yeah, this violates Jersey law. There's this Delaware case, and then there's a statute, which again, he quotes, and it definitely, I'd say, definitely not on point. Lowenstein did not point to the statute, because they were right in not pointing it. It doesn't, what the statute, and it's one in Delaware, there's a mirror one in Jersey, says you are permitted to make Jersey or Delaware, depending on where you are, the exclusive forum to resolve Jersey law matters to Jersey or Delaware law matters to Maryland. That's what it says. You are permitted to do that. And it says expressly, without limiting the general provisions that say you can have a charter or bylaw provision that deals with the relationship between the shareholder and the company. The linchpin of this is does the purchase of a security, make it purchase for a second, the purchase of a security alleged to be fraudulently induced by the company, is that a matter between the shareholder and the company? And I think it's obvious, because they created the relationship. So I think it's not, contrast with a tort case, right? I have to be a shareholder of a company. It makes chemicals. I suffer product liability damage. No, that, you couldn't have a bylaw provision requiring me to go into anybody's court on that tort case. It has nothing to do with the shareholder-company relation. Or you have a contract. You're a vendor to the company. You have a contract. Similar. Nothing to do with your shareholder relationship. You have, it's coincidental.
So we're going to, let me get 30 seconds,
Sure.
not to the last minute on the debate, but to point out the consequence of
Sure.
permitting bylaw provisions, which are contractual relationships between shareholders
Agreed.
and the corporation.
Actually, they have to be in order to work.
And arbitration clauses are contractual in nature. But if you were to require arbitration of securities fraud claims
Yeah.
and eliminate class actions, you're also eliminating virtually all discovery. There's no discovery in arbitration. You eliminate judicial supervision of settlement, so you can buy off, the corporation can buy off the plaintiff, and you really don't have the private attorney
That's correct.
action.
That is correct.
I say this as a defense lawyer, formerly, but it truly will have absolutely huge reverberations.
When I say, you're looking at it in a very micro way. Let me add why I think your view will not hold. Not in the legal sense. Who owns stock today in U.S. companies?
Institutions.
Institutions. Take the top 4 institutions, BlackRock, State Street, Vanguard,
Mm-hmm.
and increasingly Fidelity.
Mm-hmm.
What is their share of the U.S. market?
Big. There's an antitrust thought floating around in respect of that. That's
Yeah, but they are holding. Now, you go to them and say, there's no class action, there's arbitration.
Yeah.
How much capital are they going to provide to those companies?
I don't know. It's an interesting question.
I'm going to tell you the answer.
Okay.
Zero.
And why do you say that?
Because, listen, right now,
Yeah.
there's Climate Action Plus. Okay, you know what Climate Action Plus is?
Climate?
Action Plus.
No, I'm not sure.
It's large institutional investors right now doing corporate governance work,
Mm-hmm.
okay, on everything. Okay?
Yeah.
Is it for reputational businesses? No. Who's backing it? BlackRock, Vanguard. Who has the money?
Okay.
Right? So basically, activists, why are activists have some stake? If BlackRock says, I don't want to back activists or anyone else, all this stuff goes away. So even though we have, and I've taken a lot of courses, I've written on activism, you're forgetting capital markets will work towards who are the providers of capital. And the providers of capital don't like arbitration per se. Why? Because they've been hurt. managers have had, the WorldCom, the Tycos, etc.,
Yeah.
right? Staggered boards are being removed at a huge rate. So it's not, I mean, it might be a case here, there, but it's going to.
But they're gonna, the same people, those very same four big investors, are paying a hell of a lot of money through their company
They, remember,
to compensate the plaintiff class. So they're moving money between one pocket to the other.
yeah, but you gotta.
And plaintiff counsel are taking 25-30%.
So let me ask you this, who provides money to BlackRock? Who's the major?
Right now, it's ETFs, that's for sure.
No,
It's
no.
ETFs, come on.
Yeah, but even ETFs, listen, I've had great ETFs, okay? So, ETFs is just a fact. One last one, okay, one last.
One more thing.
Yeah, one more.
What you add, and that's it.
Easy peasy, as you usually say.
Yeah, that's a term I learned in
Yeah,
law school.
so I need to have it over. The main thing to remember is pension funds, what do they think about managerial malfeasance?
Mhm.
They think it exists, every manager's a crook, right? Not necessarily. So they will tell BlackRock, we hate managers who do material misstatements, etc., whatever, you know, in there. So you think BlackRock is, that's where their money is?
Well, we'll see. I don't know. Like I say, there's two different things here.
I
One are the
understand,
legal
yeah.
principles under which this is purportedly not permissible, which I think don't exist. And there's separately a question of whether it can be put through.
Les, how about section 29 and the prospective waivers of securities law, which are not enforceable?
Not a problem, because the Federal Arbitration Act says you can go into arbitration, and that's a perfectly good vindication. Indeed, they reversed Wilco v. Swan, right? Wilco v. Swan, 1954 Supreme Court case, 33 Act treated arbitration agreements as an impermissible waiver, and then they reversed that in 88 with a couple of American Express, Shears and Lehman cases, one of the 34 Act, one of the 33 Act, and they said, no, Federal Arbitration Act provides an appropriate forum. It's a perfectly good vindication. Definitely not a 29.
And the end.
Definitely not a 29.
Why don't we should conclude the class with thanks and then put your question to Les when we're,
Sure. I'll wait till everyone's in.
yeah. You want to conclude? This is great.
Thank you.
Thank you.
All right.
So the other